Hi, welcome to SERMAPod. My name is Brian Rosenblatt. I am General Counsel and an Advisory Board member for SERMA. It is a pleasure to get to host today's SERMAPod. I know my colleague Rich Lenkov typically takes these, but this is one that I've been looking forward to. With us today, returning today, is law professor Rebecca Delfino. Professor Delfino is a professor at Loyola Law School in Los Angeles. Her background is just legendary. She is an expert on deep fakes, AI, amongst 1,000 other things. Today's discussion is really a continuation of the previous discussion that Professor Delfino had with Rich regarding deep fakes. And since that discussion, we've had a few new developments. And the key one, the primary one that we want to start with, is the ELVIS Act, legislation based out of or from Tennessee. It is a very, very special piece of legislation, not simply because it's named after Elvis Presley, and I am wearing my blue suede shoes today, but it's a very important piece of legislation. Professor Delfino, I'm going to let you go ahead and jump right in and tell us a little bit about it.
Sure. Thanks for allowing me to join, Brian. So the ELVIS Act is leave it to Tennessee, the home of Elvis, to be the first in the nation state to create a right of publicity for voice cloning. Now that notion that we protect voices actually began in California, but Tennessee is the first state that recognized that voices, simulated voices, deep fake, cloned voices, voices created entirely by AI that are meant to sound like real individuals, deserved protection, not only in the as a civil right of action, but a criminal action. So Tennessee is really the first in the nation to be out protecting voice artists, and actually anyone. It would apply to you and I, Brian, podcasters, average individuals, voice actors, anyone whose voice is simulated and then is released, published, and held out or allowed to be represented as the person who it sounds like. So it's a really unique act, and I'm happy to talk about some of the things that makes it special and where I think that the law is going, because I think other states, including California and Illinois, are looking very closely at what's being done in Tennessee.
It's funny you mentioned that, because Illinois last week passed House Bill 4875. It was just signed into law by Governor Pritzker here in Illinois. Enhances Illinois' right of privacy, right of publicity laws, but it almost exactly mirrors the ELVIS Act, which I suppose is not a comment about whether or not Illinois can do something original, but sometimes flattery is, copying is the best form of sincerest form of flattery, right?
That's right.
One question that comes to mind, of course, is going to be, why are there only two states? Why not New York? Why not California, where you would think the bulk of the industry is? And then, of course, there is no federal right of publicity, right of privacy law. Why not? Are we getting there? Are we close to that? Should we, or should this be left to the states?
Great question. You're correct. There is no federal right of publicity, but there are two competing bills, the No Frauds Act and No Fakes Act, that were recently introduced. They've been working through judiciary and several committees, which seek to create almost identical protections to what has been adopted in Tennessee and what apparently is about to be adopted in Illinois. Right now, there are currently 39 states that have a right of publicity, and there are only 3 of them, California, Illinois, and Tennessee, that actually protect voices. Typically, they just protect name, image, and likeness. Voice is something that's been added to the right of publicity, in part, I believe, because one of the easiest things to clone, replicate, or use AI to duplicate is the human voice. It's the technology is much more sophisticated, and voices are so unique that it's easier to create a voice clone that is believable than even visual representations. Audio digital images are a little more challenging to create and fool the observer, but voices are easier. And so I think that's why, and of course we're talking about states, especially Tennessee, where there is a huge industry, specifically the recording artist industry, where they would have a unique interest and drive. And it's interesting. I think you had asked, what about this in terms of should it be the state, should it be the federal? At the federal level, I do think I think that the federal protection that will emerge when it does, if it does, right? The federal government, the federal, our policymakers are sometimes have a few more challenges in getting consensus around these things, around these sorts of, especially new technologies, are a little bit more challenging for them to endorse and adopt, and they're subject to all kinds of additional pressures in terms of the industry and others who may be concerned about First Amendment concerns in this space. But the states are really great laboratories for this. So just if I may, just talk a little bit about what's so unique about what they're doing in Tennessee that I've actually never seen before, and that doesn't necessarily mean it's. I haven't really decided whether what my feelings are about what they've done, but like a lot of new technologies, the first response tends to be, oh my God, let's go at it with everything we have, and what we end up with are laws that are great in terms of protecting rights, but might be a little broader than ultimately would the interface with other laws and interests accept. So the ELVIS Act, what's interesting is it applies in a way that no other right of publicity applies, not only to beyond typical celebrities, but as I said, to everyone. It also does something interesting. It gives standing, which is the right to bring a lawsuit, not only to the individual whose voice has been improperly replicated and their estate, right? Because this right of publicity lasts for 10 years beyond the individual's death. But it also gives that right to others. So the recording label, right, or anyone else for whom has been given authority through contract or a services agreement, professional services agreement, to use that voice. So that is really unique. That extension of standing to the non-artist, to a record company.
Makes a lot of sense, though, because if I can sign a recording contract for my voice, God willing, it'll never happen, but if I were able to do that, I would want that label or any of the licensees of that label to exploit the use of my voice so that I can be making money on it. I would want all those business partners able to use that as much as humanly possible.
And that might be useful, but it also sort of creates this conundrum between the voice artist and the entity that might be wanting to bring a civil action, or even this is a misdemeanor, which is also super unique, that someone could suffer a misdemeanor conviction for the use of someone's voice. But that might cause some issues between the artist and in terms of their branding and their imaging, and what do they realize what they've given away, and so forth. So there's that piece which makes it really interesting. The other thing that makes it interesting is that it not only creates a right of action for the use and publication and distribution, it also creates a right of action against anyone who makes available any of the software, AI tools, or tech services that can be used to create these recordings. And that's really interesting. So, and this now we're starting getting into the areas where I think it might be subject to challenge. So if someone supplies software to someone, knowing that it could be used in a way to create a voice clone without the consent of the individual, then that person would be subject to liability as well. And that is very interesting. And I can tell you that is not currently in the federal act. That's not in California. It's a super broad extension of what the rights would be, and maybe not entirely necessary. Maybe a little bit of overkill to create liabilities for software manufacturers or individuals who use tools are not defined. Neither are tech devices. So it's very, very interesting that it's doing that.
It all sounds like it follows some to the extent that if you are helping facilitate an infringement, that you are, collaterally involved. You are on the hook for that. That doesn't necessarily mean that if your technology is used in a perverse or corrupted manner, that was never intended. But if you're doing something that is intended to allow for this, I don't know. Is that a good thing? Is that a bad thing that it be permitted?
Yeah, so I don't know the answer to that. I do know though that that the closer you get into the chain of creation, it makes sense to perhaps impose some level of culpability on that. But the way the act is written, it arguably could apply to someone who creates software that they may not they may be very far out in the chain of responsibility. And realistically, yes, they may be sued and they may get out of the lawsuit relatively early. But the threat of litigation,
objected to that lawsuit.
Right, exactly. The threat of litigation is a huge deterrent to the development. I was going to say to the development of technology. This is to innovation, to the support of creation and creative spaces. I'm not sure we want to kind of have that disincentive.
Well, that's exactly right. And I represent many different companies, but I've always represented artists and songwriters and creators. And I will staunchly fight anything that is potentially going to stifle their ability to be creative. I'm a hypocrite if I don't offer that same protection to technology companies, though.
Well, right. And the reality is, I'm sure you'd want your artists to be able to use the software. And the fear is that by creating the potential of liability, it will disincentivize the development of these tools that your artists may want to use. So that I think is a valid concern, and why the ELVIS Act, I think it's well intended. I think that it provides important protections to artists, and to the extent they've entered into contracts that also have those need the valid protections as well. But like many areas, when policymakers are creating new laws, sometimes they bite off more than they thought they were chewing. And so we'll see if how it withstands muster, how when it's evaluated. I mean, even some of the exceptions that have been built into it, I think are a little vague. There's an exception for de minimis. I think the language, I had it up here earlier. It was interesting. It's something that
have to make a living too.
Right. Fleeting and incidental. I'm not entirely, they do. By the way, I don't disagree with that, but I'm not entirely sure what fleeting and incidental means. And there's a number of different elements of it that raise some concerns, and that also you can see at the federal level there's been a lot of work by a number of stakeholders, both in the recording industry and SAG-AFTRA, different entities who have been working to try to massage language on these bills to get a compromise that is both protective but doesn't to undermine ultimately what's intended in the creative spaces.
Yeah. It's an interesting conundrum. You had mentioned that on the federal level, some of our congressmen, some of our senators that are trying to push are having difficulty reaching consensus. And part of that is obviously going to be, I don't think that the difficulty is people don't want to protect artists or people want to make sure that technology is being used properly. But I think that there's a lag in people's understanding of what the technology is, how it can be used, how it can be exploited either properly or improperly. I think that there's then you also get into a dichotomy between East Coast versus West Coast, New York versus California, and the traditional concepts of a right of publicity and a right of privacy. The Ninth Circuit and the Second Circuit look at these rights very, very differently, and the history behind that. New York, which had, back in the day, had all of the newspapers, their constituents wanted to be able to use celebrities' images however they wanted. California, on the other coast, had the film studios that saw a need to protect the celebrities. And then, of course, the celebrities want to exploit and monetize control their own images. And I want to say I know. I believe that has been one of the largest factors in preventing federal right of publicity, right of privacy years. How do we reach that consensus? How do we get there?
Right,
and quite frankly, where do we want to get to?
Right, and I think that's a fair question. And then there's one other element I would throw in, which is the First Amendment. Right. So we
can trim a little fat off that.
Right. Well, I mean, I think there are valid First Amendment fair use concerns that a variety of folks have that they want to protect, that when discussions arise at the federal level, that is always, I mean, in nearly every single effort, and there've been, oh gosh, in the area in regulating deep fakes, whether it's in this area of entertainment, sort of in the right of publicity end of it, intellectual property end, or on the other end, criminalizing non-consensual pornographic deep fakes, or trying to protect the electoral process. Wherever you look, where federal policymakers are trying to address deep fakes, a major elephant in the room is the First Amendment. And although First Amendment concerns extend to the states, it doesn't seem to be as front of mind for state legislators. It just doesn't, right? So they're more concerned with, we have a group who, in the case of the ELVIS Act, we have a group of recording artists who, after a series of events, like the fake Drake is the one that got that onto their radar, then they said, oh my gosh, we don't have a protection for voice. We don't have a protection for voice, and we clearly don't even have a protection for synthesized voices. So we need to do something, right? And then speaking of the coasts, right? The limitation. So the die was cast by the Midler versus Ford case, which said you don't get a copyright in your voice. You got to look somewhere else. And so, of course, and the place that one would look would be to the right of publicity. And as you say, and I agree, there are genuine interests of journalists and others that are interested in protecting public spaces and news reporting to have access to this material. all of the good news in that area is all of these proposals all of them include some sort of exception for for either parody, exactly.
Reporters privileges and
Yep,
whatnot.
all of
Absolutely.
those have been built in, and that's a good thing, right? We want to be able to allow comment, criticism, scholarship, parody, satire, and reporting of public events. So those are all in there, but I think where they really, really strain is balancing the private economic interests that everyone has that is encouraging this area of regulation, and those that are trying to strike that balance with First Amendment protections and recognizing the doctrines that have grown up in other areas like copyright and so forth. So it's a challenge. I think it's the no fakes. The No Fakes and No Frauds Acts, which are the major federal proposals that are trying to navigate the space, they were introduced about a year ago, and they've been working their way through. Believe it or not, this seems like light speed to me, compared to the way other areas of law tend to move. And they're getting there. I don't know whether this particular Congress will actually get a bill both out of the House and the Senate that they can put forward for the current administration, but they are certainly trying to I think there's a good faith effort to do these protections and strike the right balance.
One thing that strikes me is that I appreciate from our legislators is the recognition that music unifies people, and it's not a partisan issue. And we saw that with the Music Modernization Act, where both the Republicans and the Democrats came together for a joint purpose. I mean, that was phenomenal. Didn't matter whether you were red or blue or anything else. It's just that's the appropriate thing to do, and that was a great thing. So hopefully we'll see that. I do have a question for you. I just want to ask you about a clarification. We talked about most of the states do have provisions for name, image, likeness, but they don't include voice.
That's right.
California, Illinois, Tennessee do. So we're looking for protection for voice. Why wouldn't voice be included with likeness? Because I'm a fiend. When I hear something on television, when I hear something on radio, I can't recognize an actor's face to save my life, but I can pick that voice out from the rarest of circumstances. So why wouldn't voice be included with that?
Yeah, that's a great question, and I suspect the reason that it hasn't been included is that it's never been separated from other aspects of likeness. So if someone is going to have a visual likeness, like have someone impersonate someone that's famous and have it appear in a visual space, like on a commercial or so forth, it has historically rarely been divorced from the visual image. So I mean, that's what made the Midler case so unique, and yet not, right? So the Midler case, Ford Motor Company asked her to appear in one of their commercials and sing one of her songs, and she said, "No, I don't want to do that." And so they got an actress who looked like her, and then had her sing, and it sounded like her. And it was really the confluence of those two things that led the court, although they had interesting language about the uniqueness of the human voice, but led the court, led her to bring that lawsuit. And they ended up saying, the best you can do is a right of publicity. But even that case, the voice itself was not necessarily divorced from the assertion of how it appears.
Likeness is the overall, and voice is a subset.
Yeah, and it's really been these deep fakes that have allowed the voice cloning technology, that have allowed that aspect to be exploited in a way it was not exploited before. I mean, you could take my voice, manipulate it through particular AI, and I could sound like many, many, many actresses. That was simply not possible without the advent the advances in technology that we have in the last 4 or 5 years. And so I guess it was a problem that hadn't yet fully appeared in a way that the others had before that.
Very good. So where do we go from here?
Well, I think I would encourage states to continue to experiment with their ideas about protecting. I don't think it's particularly, now there's some great models of how to put together these laws. And I don't think it's particularly challenging to do. Nor I agree with you. It's relatively a bipartisan issue that many would support. And so I am a fan of the states continuing to experiment with what is appropriate for their constituency, while at the federal level they continue to work through some of the questions about how to balance the First Amendment interest against the industry interest, in the hopes that it is certainly my hope that in the near future, if not this Congress, then the next, that we actually do have a federal right of publicity. I think it's an important value, and especially in anticipation of technological developments that neither you nor I sitting here can anticipate. That the technology is not going back. So we that are in the field of the law have to keep up with it as best we can, which is not easy, as you know.
Well, I can tell you that for me, it's very easy because I get to turn to Professor Delfino for my questions. So I want to thank you very much for joining us for today's SERMAPod. It's a pleasure to speak to you on this. As a quick reminder, this is the second time Professor Delfino has joined us, and the first time you're a guest, and as someone mentioned earlier today, the second time you are family.
I'm so happy. I'm so happy to be a member of the SERMAPod family. This is fantastic. This is an area of law that's going to continue to evolve, and we all will enjoy watching it. And I'd be happy to be back anytime. Thank you so much for having me.
Be careful what you offer, because we're going to take you up on it. Outstanding. Thank you very much.
You're very welcome.